Master's MS from Computer Science and a law degree, both from UNC, and I was just being very impressed by the fact that they were only a year apart, which means he was doing both of them at once, and I can't even imagine doing that. And he's going to talk about IP and software.
Thank you very much.
Okay. First, I have some handouts in the back, so if anybody needs the handouts, they're there. Okay? Anyway, I got as I mentioned, my MS in '89 and went on to get my law degree here. Right now, this weekend is the 25th anniversary of the law school, so I'm juggling both festivities here. I gave a presentation at the law school earlier this morning on a similar topic. You might be nice to those of lions and tigers and patent trolls, oh my, but it's based on some of the aspects in this talk. I'm also a professor in the computer engineering department at Southern Methodist University in Dallas, Texas. I used to live and work there many years ago and developed a relationship there. And I teach a class there on for engineers, business people, and other people in industry about the basics of intellectual property. Okay? In addition, I delve into the history of technology and also the history of law and how technology and law intersect and throughout history, such as in the creation of the patent and copyright statutes and the rules that we live by today. Okay, so I thought I would start with some levity. All right, there we go. Okay, history of software. Okay, I'll try not to be too boring with you and everything, but really, history of software begins with the Greeks about 200 BC, when they had the Antikythera device, which was the first analog computer. It calculated calendrical and astrological dates for the Greeks and the Romans at that time, and it was lost to history until about 1900 or so, 1903, when it was found off the island of Antikythera. And we're still trying to figure out how it worked and how they had the engineering skills of that day. Moving forward through time, the abacus and other technologies, but logarithms and slide rules pervaded for a long time, hundreds of years. I will admit, I was the last president of a slide rule club in my high school. Moving to the 1700s, the French loom works, crafting all these complicated weaves and everything. It was all automated, as you know, by Jacquard and others, with punch cards, which are used to this day. Now let's just risk it. No, wrong light. Come on. Okay. Charles Babbage, and of course the first programmer, Lady Ada Lovelace. They were involved in constructing and programming the first computers, the difference engine, and then the analytical engine. Samuel Morse, creator of the telegraph. It transformed society from allowing information to pass at the speed of light instead of the fastest horse. Moving forward, I got quite a bit of slides, and we'll get to the provocative stuff soon enough. Herman Hollerith was in charge of the census of 1890, which was a burgeoning nation. We had tons and tons of information, and he was in charge of that. Who knows what Herman Hollerith's company ultimately became? IBM, exactly. So anyway, history of software. The previous speaker got into this, the mainframes in the 50s and 60s, the birth of the first major computer languages. But software had a huge driver in the Cold War and the space race. And of course, our own Fred Brooks was in charge of the IBM 360 operating system. The great unbundling in 1969 had to do with the split between the mainframe and software, where software became an independent tool. Up until then, software was primarily tied to the machine. The software industry was born at that time. Microprocessors and the microprocessor wars throughout the 70s, 80s, and 90s. And new communications protocols, and of course the birth of the personal computer, enormously transformative event in our world. Come on. The birth of the internet, although we were using such tools beforehand, even when we were grad students here, but it opened up to everybody in the early 90s and created everything. And of course, gaming and other technologies are transforming things, internet browsers, search engines, and everything. I pretty much stopped in the late 90s because it's exploded after that. So you all know what these technologies are. Turning to the law part, okay? patents require a variety of specific things. Primarily, the invention has to be new or novel. Okay? That's the primary component. Another component, a major one, is it has to be non-obvious. It cannot be a trivial distinction over what's already known. Okay? There are a host of other requirements I won't get into, but this is the one that's of controversy of late, the threshold statute, so to speak, Section 101. And it's pretty broad in its language. Any new and useful process, machine, manufacturer, or any new and useful improvement thereof. Okay? But technologies now are running against this, and we're dealing with this right now. There are certain things you cannot patent. Okay? Laws of nature, E equals mc squared, gravity, things like that. Natural phenomenon. Samuel Morse got into an issue with some of his patent claims in the 1830s because he was claiming electromotive force as a whole. And the Supreme Court at that time said, no, you can't claim the principle. You can claim an application of the principle, which he did. He got patents for his code, and he got patents for the using of his machines. And of course, with abstract ideas is another one. You just can't, the idea cannot be too abstract. It has to be tangible or concrete in some fashion. It has to be formalized. The concern in patent law is to, you want to prevent monopolizing of scientific principles, or more recently, with some of the recent cases, business tools and things like that. We'll get to that in a minute. I'm just going to run through a few of the early software patent cases that made it to the Supreme Court. All right, this is one of the first ones. Gottschalk versus Benson. The court held against the patent at that time because they felt it co-opted the algorithm itself. In this case, it was a binary coded decimal to binary. Sorry about this. This is jumpy. Binary coded decimal to binary algorithm. Okay, so they held against that one. Moving forward, Parker versus Fluke. This one had a catalytic conversion process where software was being applied in an industrial process for catalytic conversion. And it generated a number, which was the alarm unit. The court, in most patent attorneys' view, this court, the decision is not a good one. They said it's just a number. You can't patent a number. But it created a negative impression in the industry. People didn't patent as much. And that had repercussions later on. Diamond versus Deere, moving into the 80s now. Remember, this is the beginning of the PC and software. Here you had a case where there was again, an industrial application for curing rubber, and there was a scientific formula, the Arrhenius equation, which was involved. And it got challenged, and it went all the way up to the Supreme Court because of the use of this equation. The court pretty much held that it's okay, it's using the equation, it's not co-opting the equation. All right? Anybody else can use the principles of the equation, but in this case, it's a specific application of it. So in this case, it was deemed okay. All right? And at the same time, these issues were going up in the Supreme Court. They were also in the lower courts and also at the Patent Office trying to come to grips with this. And they came up with a variety of tests that they could use to try to get a handle on this. Okay? Diamond versus Chakrabarty was really a revolutionary case at its time. It sort of changed things a bit. It demonstrated a shift to uphold patents, even though it was a 5-4 decision. But this had to do with a bacterium that was re-engineered to eat oil. Okay? So you had an oil spill, and you would introduce this bacteria to eat up the oil in that. So there are lots of quotes from Jefferson, and also there were some quotes from the legislative history in this big Patent Act of 1952 that said that you can patent anything under the sun that is made by man. Okay, so that was a good indication we can move forward. Sorry, I'm moving forward backwards. Okay, things were moving along into the 90s. Again, the internet was exploding and everything, and then comes the State Street case. This had to do with the bank was trying to manage and consolidate mutual funds by moving things around using the computer and all that. And the court here was a federal circuit, which is a lower court, but it's the appellate court charged with all the appeals from all the district courts to the one federal court that hears patent appeals. They upheld the patent. So software patents were deemed okay. More importantly, at this time, they felt that business methods were okay as well, that the objections to them were ill-conceived, and that there were the other standards, again, the novelty, non-obviousness, and other ones like 112, which is description. All these other requirements were much more stringent, and they held sway, as opposed to just letting Section 101 stand in the way. So anyway, moving forward now, since then, okay, since then there's been a lot of patenting. A lot of people are trying to obtain patent rights, and a lot of these things are of immense value. And when something is of considerable value, they will litigate it. And a lot of these cases have gone to the Supreme Court. When I first started practicing law in 1990, you may have 1 or 2 cases every other year making it to the Supreme Court. Maybe, all right? You would go sometimes 2 or 3 years without any patent cases. Now, this is just in the last 10 years or so. This is just a small fraction of the cases that have made it to the Supreme Court on a variety of issues. Okay? I could probably spend 10 minutes on each one of them, but I'd be happy to talk to anybody outside on this. But we'll talk about the primary ones in a second. Here are the cases from last year alone. Primarily, the issues there had to do with the second and third one on the attorney's fees awards, that there's a statute in the books already that if someone brings a case that doesn't have merit, that the loser may have to pay the litigation fees of the winner, okay, as long as the case doesn't have merit. The reason I bring this up is because there's current legislation in this area. And then the other big one is the last one there, the Alice Corporation versus CLS Bank. This had to do with a software technique to implement some escrow mechanisms within the bank. And the court had a very specific decision here. They pretty much said that the mere fact that you are taking this technique and putting it on a computer is not enough for patenting. Okay? It was a very narrow decision. We're all unclear as to what this means, but the court did not necessarily go out of their way to undermine the patent system or software, but it's ambiguous. It's not unusual for the court to be ambiguous. They were ambiguous in those 70s cases as well. So we as patent attorneys are trying to figure out what does this mean, how best for us to deal with this with our clients. In Congress, I'm practicing out of Washington, D.C., so I get to attend some of these things. And it is interesting, I will say that. There's an immense amount of lobbying, again, with the value of patents out there. And patents are really pretty much a proxy for market share. Companies that want market share will fight to get that market share however they can, whether through better distribution or whatever. But they'll also use patents to undermine another company so that they can increase their own market share. So patents are getting unfairly tarred and feathered, so to speak, in this. There was massive coordinating lobbying for almost a decade here, but it culminated in 2011 in what the AIA, or the America Invents Act, which was signed into law. I witnessed a lot of this. I attended a lot of the hearings. I personally do not care for the America Invents Act, but it is the law. It was very fast passage as well. It didn't get good consideration in my view. There's a famous quote by Chancellor Bismarck saying, "The passage of laws are like the making of sausages. You don't want to know how sausages are made." All right? I witnessed the law being made, and it was ugly, I will say that. Currently, there are numerous new legislation being submitted for further patent reform, even though that the Supreme Court has acted considerably in numerous cases of late, and the America Invents Act is out there, but also there's been a drop in litigation. Okay, the main issue is the loser pays system. That's the current legislation they want to have, that if you lose, you're a plaintiff, you're wronged by a large company, and you sue that big company. If you lose, you may be liable for that big company's attorney's fees. To me, this is devastating to the patenting process, and we're hoping that it does not go forward in the fashion that some people want it to. The American Invents Act, the main thing here was it changed us from what's called a first to invent system, which was okay from our founders' time, 1790, to 2011, we're now a first to file system. So it rewards the person who is first to get to the patent office with their patent application. Not necessarily that you spent 3 years on it in private trying to work it out. So all I can impress upon you is consult a patent attorney quicker. I had to move faster. Right now, there's a lot of large corporations feel hostile towards patents because they're being sued. It's as simple as that. They want to change the patent system because of that. Henry Ford was sued by a lot of patent people in the early days of his company, and he did not like that. He was running for president, I think it was 1924, and part of his platform as president would be the abolition of the patent system. Okay? A lot of companies, Halliburton in the past and some other big tech companies now, want to curtail the patent system. They're getting sued too much. But you know, if you have a cell phone, does a cell phone have to have a GPS in it? Do you have to have these features? You add these features, you leave yourself open to the possibility of extra litigation. This is a cost of doing business. Now, when I teach this class, you know, I always have the counterpoint. All right? I'm a patent proselytizer. Okay? But the assumption here is that innovation is good. Since you're all in computer science and everything, I think you think the same thing. That it's socially beneficial. The patents are a reward for the contribution. This is a very Western capitalistic view, Calvinistic. It was the view of our founders. Many question this motive, though. You know, non-Westerners that are averse to capitalism, preservation of the status quo, like in India and places like that. They have a different viewpoint on these things. The greater good over the private incentive, okay? Uncompensated fame. Jonas Salk as opposed to Thomas Edison. Thomas Edison was the quintessential United States inventor, whereas Jonas Salk, I have the utmost respect for him, 16-hour days every day for years on end to get to the polio vaccine. But for some reason, he and his university were unable to get the patent, and he just said, when Edward R. Murrow asked him about this, he says, well, you can't patent the sun. He took a really high horse on this, and I just felt that, you know, you had a situation where you couldn't get it, but in my view, it was a dubious motive for him giving this statement. Anyway, well, let's move towards the end here with patent law. Our own Abraham Lincoln was a patent attorney. Okay, he actually was involved in litigation with Cyrus McCormick and his reapers in the 1850s, and he was also very, very interested in innovation. And you just read his quote there. I mean, it's he had a lifelong passion for technology itself. I wonder, you know, if he had lived, what he might have done. He's also the only president to have obtained a patent. He observed that boats and things like that would get stranded on the shallow waters in these shoals, and he developed a pontoon system to, with air, lift them up so that they were able to drift out into safety. So with some guidelines. Let's see, I'm sorry, I had some notes here. Let me just get it. So some takeaways, okay, from this presentation. Although technology is moving quite rapidly, indeed, we're living in a quite marvelous age. You know, just as in the 1970s, the court and Congress are struggling to come to grips with the changes in the technologies, and we're again faced with the possibility that the patent laws may be curtailed too much, whether by negating software patentability and new technologies patentability, or the ability of the inventor themselves to litigate in their invention in a loser-pays system. The threat is that innovation will be stifled, and that companies will resort more to trade secret instead of the open system, which is the patent system. And also that the American innovation engine may stall because of this. As a practitioner, it's my job to navigate through my clients through these shoals, just like Abraham Lincoln, so to speak, and to help them protect their various innovations. So basically, you want to avoid, right now, if you're seeking patents or whatever, you want to avoid abstractions. You want to claim the application of a principle and not touch on the principle itself. The future technologies, however, are getting more and more abstract. This is a tricky thing. And in claim drafting, which is part of the patent process, I must articulate in certain language what it is that we're going after. And when the invention becomes more and more abstract, it's a little bit more difficult to make that concrete. So you attack this in a variety of ways and try to make it more and more tangible as best you can. So anyway, hold on. I got to get the graphic to work. Hold on. Ay, this thing is tricky. Come on. Ay, sorry. Wow. All right, hold on.
Hit the buttons.
Exactly. All right. I wanted the graphic to work. I brought it with me. So anyway, we're living in the information age, the biotechnology age, incredible advances in biotechnology. And now in nanotechnology, personalized medicine, 3D printing is now transforming our world. Large numbers of emergent and convergent technologies out there, an acceleration of marvels. So with that, I thank you very much for letting me be here today.